We are back after a lunch break, and we'll return to Mr. Powell's cross-examination. Let's see, is Mr. Sayer with us? No? Or Ms. Bradfeud, perhaps on the platform? No? All right. Mr. Rankin, do you have questions of Mr. Powell?
Thank you, Madam Hearing Officer. I do. Good afternoon, Mr. Powell. How are you today?
Doing well.
Good. Adam Rankin. I'm here representing OCC. And I just want to say at the outset, thank you to the division and yourself for engaging with OCC during the course of the lead up to this rulemaking to discuss some of the issues and take into consideration some of OCCC's requests. I appreciate it. Obviously, we weren't able to reach agreement on everything, at least prior to the rulemaking hearing. So that's where my focus is going to be today, is on the areas we haven't yet reached agreement. In your testimony, in your written direct testimony, I see statements about the division's support for certain aspects and different specific provisions in the rule. And for example, I'm going to pull up on my screen here one particular. Oh, I got bumped off. 1 second. Oh, I got bumped up big time. 1 moment. Madam Hearing Officer, I have to re-log onto the system. I apologize. Can you give me just 2 minutes to do that?
All righty.
I apologize. I didn't realize I got bumped off. Actually, I'm okay. I'm back on. All right, good. Let's see, but it's not letting me share just yet for some reason. It looks like I have sharing authority, but it is not letting me share. Well, I'll try to work through this without my screen sharing ability. On page 4 of your direct testimony, lines 6 to 8, I don't know if you have it in front of you, but you state, essentially, OCD supports the requirement for single well financial assurance once wells reach a production threshold where operators tend to plug and abandon the well. Did I read that correctly? Do you recall that from your testimony?
I didn't. I don't have it in front of you, but I'll believe in your reading of it.
All right. And my understanding is that that statement is the division's support for the proposed new marginal one well financial assurance category in the proposed rule, correct?
Yes.
Okay. And let's see if I can get back on to sharing again, because it's so much easier to share. There we go. And that's this provision under the proposed rule 1915-89D, subpart 2, which requires the proposed one well financial assurance for marginal wells, correct?
Correct.
Okay. Now this addresses one aspect of the regulatory or the specific regulatory recommendations made by the LFC in that LFC report. That's Division Exhibit 18, correct?
I believe so.
And that's the recommendation to provide for a definition of marginal wells and then provide for additional financial assurance for those wells, correct?
Correct.
Okay. But I don't see anywhere in your testimony, in your written testimony or your rebuttal testimony, where you say expressly that the division supports applicants' proposed creation of a new operator financial assurance category that Mr. Peltz testified about, where operators with 15% or more marginal wells and or inactive wells in their portfolio are required to pay $150,000 financial assurance for each of their marginal wells and or inactive wells and each of their active producing wells. Do you state anywhere in your direct testimony that you actually support that provision?
Well, the 15% I think originally came from the OCD. I think I addressed it last week when I was talking through some of the percentage things. the general overview of that provision. I think we were open, expecting some dialogue back and forth about the 15%. And where I specifically addressed this as I was going through my direct was in my slides where I went through the rule section by section.
Okay, I'll pull that up because I know exactly what you're talking about, and I'll go to that in just a moment. I'm going to, just for ease of reference, I'm going to just refer to this category, and this is under subpart 3 of this rule here that I'm highlighting on your screen. Agree, where an operator with 15% or more wells triggers the inclusion of all the other wells that they operate under this one well financial assurance provision, correct?
Correct.
So I'm just going to refer to that provision going forward. I'm going to call it the marginal operator provision, okay?
Sounds good.
Okay. So when I read your testimony carefully, I see that you identify expressly 3 benefits that arise from the proposed rule that address the problems that you and the division witnesses have identified in your testimony. I'm going to just walk through those. Okay. Go back to your direct on page 2. And and I've got them again, rainbow, okay, because it's so much easier to track, okay. First one's in yellow, okay. The proposed rule would increase bonding for wells that are at or near the end of their productive life cycle, at which point they generally present a higher cost for plugging and remediation. So this is the first benefit that you've identified, and this is addressed by having the new marginal well financial assurance category for one well financial assurance applicable to wells that meet the marginal well criteria. Agree?
Yes.
Okay. And again, this is for, as you testified, for wells that are at or near the end of their productive life. Correct?
Yes.
Okay. Now, the second benefit that you've identified here is in green, and that's the proposed rule provides a structure around temporarily abandoned wells, allowing wells that have a reasonable possibility of staying productive a path to do so, but then also requiring, if they're simply being, delayed being plugged, then they're required to do so in a more expedited fashion. Correct?
Yes.
And this concern or benefit is addressed by the specific proposal to modify the rules around temporary abandoned wells and to identify earlier in that abandonment process wells that have no beneficial use, creating a pathway for them to be plugged without having to go through an NOV compliance process, correct?
Correct.
Okay. So those are 2 very specific targeted ways that the rule is designed to prevent wells from being orphaned. Agree?
Yes.
And then the third here is the blue provision states that the new proposed rule provides structure to improve OCD's ability to oversee the transfer of wells into higher risk category, to companies that may have compliance history issues or insufficient capital to meet their plugging obligations, correct?
Yeah.
Okay. And then this provision or this concern of the division is addressed by the registration and certification provisions that are in the rule, right?
Yes.
Okay. Now, these 3 benefits are the result of, I would say, and you tell me if you agree, relatively narrow, tailored, targeted provisions that are adopted or proposed to be adopted in the proposed rule. Agree?
Yes. They're related to provisions in the rule.
Okay. But I don't see anywhere here in your direct rebuttal where you expressly identify the benefit of the purpose or endorse this marginal operator category that we're talking about.
I don't know if I specifically endorse it in my direct. It's been a day since I've looked at my own testimony as whole, but I will say generally we endorse it because we're the ones that proposed it.
Okay. So if I go to your PowerPoint, one moment. You mentioned that in your direct testimony slides, and this is, I think, the slide you're referencing, slide 17 of your Exhibit 15, you do point out there's this provision that provides for the inclusion of these additional wells if an operator has more than 15% in the marginal well category, right?
Correct.
Yeah, but again, in these notes, you just say what it does, but you don't actually say that the division endorses it, right?
Yes.
But you're telling me that the division does endorse the general approach of having this marginal operator category?
Yeah, so as I explained in my direct testimony, this was a portion we actually expected dialogue back and forth from industry on whether 15% is appropriate, 30% is appropriate. What we see is operators, when their wells start failing, it's kind of a cascading effect that they continue to fail. And at some point, if we can get bonding on all those wells, we reduce the risk, because once a operator reaches the point, as we showed on the C115 list, all of their wells then become our problems and not just the problem wells.
Okay. So now, talking about this provision, the marginal operator provision, as we discussed, would capture more than, as Mr. Purvis testified in his slides, shows that it would capture more than half the state's oil and gas operators, forcing them to pay one well financial assurance, not just for the marginal wells, right, but for every other well that's active and producing in their portfolio. Agree?
Yes and no. I think there's some nuance to that I think was evident in the C115. I would say that if this well went into effect, it wouldn't be half starting tomorrow that would apply to, because as I showed on the C115 list, there's 25% of the operators in the state that are already inactive and are not reporting production. So it may affect at 15%, maybe another 25% of the operators.
But we don't have an analysis of what that impact would be other than what Mr. Purvis presented, correct?
You would have to do a review of our Exhibit 16 core data to see kind of what wells fell in there and then count the operators.
And same thing with Purvis. Then you have to do a cross check with Mr. Purvis's data and figure out what those operators are. And that hasn't been done, right?
Not that I'm aware of.
So all we know is that up to 51% of the current operators in the state are going to be impacted by this proposed rule, right?
Well, I'm thinking 25% of that 51% probably aren't going to pay for extra bonding because they're not in compliance today. So in that math, maybe 26% may incur additional bonding.
And you're saying that because that list on the C115 is, do you think those operators are defunct, you're saying, and they're not going to come back and pay for additional bonding?
Unless they're intentionally not reporting production for over a year.
Okay. But I guess the bottom line, though, is that 51% of the operators, whether they pay or not, are going to be impacted by this rule, correct?
Yes.
Okay. So now, was it the division's intention then to have a rule? Not only would it affect 51% of the operators, but it's going to affect 18% of wells. And I can pull up Mr. Purvis's slide here just so we can quickly see it, because it's always helpful to see the actual numbers. But on his slide 28 of his Exhibit 52, with 15% of the wells incorporated into the rule, it would have an impact on 51% of the operators, 18% of all the wells statewide, and 2.3% of the production. Was it the division's intent to have a rule that would have such a wide-ranging impact beyond what you identified and what we walked through as the three specific narrowly targeted benefits in the rule?
I guess that number slightly surprises me, that we have 50% or 18% of the wells out there aren't even producing 50% of the time. That was kind of a shocking statistic, that we have that many wells not producing on a normal basis. I didn't have a specific goal in mind when we selected that. I think if you look at that slide at the 30%, that's probably most of the inactive well list that I provide, or the inactive wells that I provided on the C115. Honestly, I expected to land somewhere in between the 15 and 30% in discussions, but those discussions didn't happen on that level. But I was shocked that 18% of the wells in the state weren't producing at least 50% of the time.
And you were shocked because you hadn't done that analysis to determine what the impact would be prior to making that proposal, right?
Yeah, I would have never expected operators were not producing 1 in 5 wells.
So prior to this rule and coming up with a number of 15% that you proposed to applicants, the division didn't itself do an analysis to evaluate prior to receiving Mr. Purvis's analysis and his testimony, did the division done its own analysis to determine what the potential impact would be?
Not on a percentage basis like this, no. We pulled up the different thresholds in Exhibit 16. went through the different thresholds, did some spot checking of wells to see if it looked like they were being produced regularly, looked at seeing if there was issues with that, and we didn't see any major issues. If an operator was producing, again, that 1,000 barrels or 50% of the time, those wells looked like they were being beneficially used. So that's what we looked at, was mainly in Exhibit 16 when we were looking at that, but I didn't put together any statistics or numbers.
So a high level, just sort of a high level scoping, essentially. Okay. Now, was the first time then that you saw Mr. Purvis's analysis when he filed his testimony and his study with as part of this case?
It was.
Okay. And did OCD do any kind of analysis to confirm his evaluation of the potential impacts?
To be honest with you, I didn't even look at the all the applicants' testimonies before this commission started, so I saw this live.
We're keeping you pretty busy, aren't we, Mr. Powell?
And I have a day job on top of it.
I know we are. I send you emails at least a couple times a week. Now, did the division then do any kind of analysis to evaluate the potential impact of this marginal operator approach on the wells and the operators in the state then?
Not a formal analysis, no.
So none of the division's witnesses, including yourself, testified on the potential impacts to operators' wells or production in the state that might occur by adopting as proposed applicants' proposed rulemaking, especially with respect to the marginal operator provision, right?
So we didn't do an all-out analysis. I looked at the numbers again. I looked at some of the companies through other enforcement data. So these numbers, again, the 18% surprised me, but getting to that 33%, 8% didn't surprise me a whole lot because of enforcement I was doing in other places and numbers of wells we were looking at there.
Okay, and then also based on the scoping you've done and to date, none of the division's witnesses, including yourself, testified to the commission whether the proposed rule and the marginal well definition or the marginal operator provision would prevent waste, correct?
I think I was actually asked that in my testimony by IPA&M shortly ago, and I believe it would reduce waste if an operator was producing their well 51% of their time instead of 1 day a year.
But so that's just a belief you have, right? That you haven't done any kind of study to evaluate whether that's the case or whether the impacts as a result of the financial assurance would actually overwhelm any benefit that you believe may occur.
Well, I think that information is simply available in Exhibit 16. There was, and I believe that's in my direct testimony, I believe there was 1,400 wells or so that produced less than 10 BOE in 10 days in that calendar year. So I would say those wells, if they started producing, if they were capable of production, that would increase tax and revenue to the state, and those wells would be used beneficially.
Sure. And then on the other hand, there may be some operators out there who walk away, do not seek to revamp or revitalize their wells, and then the division goes in and plugs them, even though maybe that reservoir has remaining primary production capabilities. Wouldn't that potentially result in reduction in ultimate recovery if the division goes in and plugs wells that otherwise would be capable of continuing production?
Again, with the 51% of production days, not just production, I think there's a lot of times reservoirs may have producing quantities, but the well is no longer capable of producing. And then that's the problem that we see when we get these abandoned wells, is the wells have severe neglect, downhole casing issues, stuck tubing, those kind of things. And if the operators aren't paying to bring those wells back on, then I don't think this rule will change it. I think it may, they may leave that well sooner, but I don't think it changes the overall outcome that well is going to get left.
So in terms of evaluating the pros and cons, the benefits and the adverse effect of this proposed rule, the division itself hasn't done any kind of study to determine what the overall impact would be, whether you can say, based on a study or analysis of the data or what you think may occur, that there's actually going to be prevention of waste as a result of implementing this rule as proposed.
Well, again, we don't make operator decisions. And I would say why we didn't do a specific study to what you asked. Exhibit 16 is an entire year of production for the entire state. And we did look at that extensively.
Okay, so we know you looked at one aspect of the potential impact, but the other aspect what the effect of the financial assurance might be on operators and whether it would cause premature plugging has not, that's the aspect of the potential impact of the rule has not been evaluated by the division, correct?
So that level of data is actually what we expected industry to bring because we don't have every company's creditworthiness. We don't have all of their financial information to know what they can and can't do. We don't know what their long-term plans are on each of these wells. That information, based on the data that we had, we set a standard, but we don't have their individual companies' information on creditworthiness. That's part of the reason why that on transfers, those kind of things, we can ask for that in this proposed rule is to be able to get to some of that as needed. Or if a presumption of no beneficial use is made, the operators can bring some of that data in their presumption of no beneficial use for evaluation. Is we open those doors for operators to bring that data to us to show us what's going on with those wells.
So as we sit here today, as the commission is considering the proposed rule, the commission has not yet been presented by applicants or the division with a comprehensive analysis assessing whether or not the proposed rule would result in waste. Agree?
I think there's general understanding of what may happen, but as far as company specific information, I don't think anybody that's testified up till now has been able to have that information because that's information held by the company.
Or even on a more general basis, I mean, even not on a company specific basis, what the potential impact would be on production statewide as a result of the additional financial burdens imposed on the industry overall, right? We don't have that analysis currently before the commission.
I think if industry wants that on a production statewide, they can pull it out at 16, Exhibit 16, because it's all there. When we looked, it includes an entire year's worth of production and includes an entire year's worth of days produced for each well. I think the data's there if somebody wants to do that study.
So you heard the testimony from applicants' two engineering witnesses, Mr. Purvis and Mr. Alexander, and they testified that they had prepared no study or analysis addressing whether the proposed rule would prevent waste or protect flood rights. Agree?
I believe there was no extensive study in that specific realm, no.
And because they had not, they were unable to testify that the proposed rule would prevent waste or protect flood rights. Agree?
I believe so.
And none of the witnesses, including yourself, have prepared an analysis that would allow the division to draw those conclusions based on actual data. Agree?
I don't agree because I think on actual data, we presented that in Exhibit 16. I think the new list that I provided on the number of wells plus the C115, I think you can calculate roughly how many wells that is. If you wanted to look and quantify that, I think the data is there if you'd like to do that. But I believe the data is there and has been presented.
Okay, but in terms of then, I mean, so you're saying that you think you can draw the data out from the database that was provided, but that analysis hasn't yet been done or presented, correct?
Well, the information's been presented, but an analysis in the scope that you're talking has not been done.
Okay. All right. Now, moving back to Mr. Purvis's testimony, we know based on Mr. Purvis's testimony that the 15% marginal well threshold proposed under the rule for the new marginal operator category is going to impact, 51% of the operators, just, without consideration about whether you think they're going to actually pay or not pay, or whether they're defunct or not defunct, just based on a company number basis, 51% of the state's operators are going to be drawn within that scope of that marginal operator provision. And at least 2.3% of the state's production, which is about 17 million barrels based on 2024 production data. Do you agree? Do you recall that testimony from Mr. Purvis?
I do, and I'm hoping actually it's not that high because if I remember correctly, the provisions of the rule give 3 years for that to take effect. So operators have 3 years to work with that unless they transfer wells, and I would hope in those 3 years they increase their productive standing.
So in your rebuttal testimony, you were referring, I think this is going to be Division Exhibit 32, I think, where you've pulled the filter from I think it's revised Exhibit 16, correct? Is Is that right?
I believe so.
Okay. And I think I heard you say that the impact of the well, of the proposed rule would be only to 3,494 wells.
I believe you would have to pull, oh, you've got it up. The 3,494 is the total of both of the columns above and does not include inactive. So that would be yes.
Okay, and it also doesn't include the additional active producing wells that would be pulled in under the marginal operator provision for any operator that has more than 15% wells that qualify as marginal, correct?
Correct.
Okay. So it's not totally accurate to say that this number is going to reflect the total extent of the wells impacted by the rule. Agree?
Well, I think this is the number of wells that are impacted based on a volumetric basis. And if the operators correct these 3,494 wells, it won't affect the others.
Sure. But nevertheless, based on the language of the rule as proposed, if it were to be implemented today, this number does not incorporate those additional wells that will be pulled in under the marginal operator provision. Agree?
Correct.
Okay. And now going back to that same discussion here that we're having about the marginal operator category. I didn't see anywhere in the division's testimony, including yourself, where there's been an analysis of any kind showing that 51% of the state's operators are actually at risk of orphaning their wells, any wells that they operate that qualify as marginal wells under the proposed rule.
Again, I don't know if 51% are going to be at risk by the time it goes into effect. I don't know their financial standing. I don't know if 26% of the operators in the state don't have financial standing to cover their wells. If they continue to operate the way they are, if they don't have that financial standing, they may be heading where the other 25% are. And that would be an indicator.
And I think I heard you say in response to one of my earlier questions that what you had expected to see was something between 30% and 50%, more along the lines of what the number of operators that showed up on that C115 list. Agree?
No, I expected to be between the 15 and 30% as far as numbers of wells, because I was surprised the 30% was so in line with the no production that those wells are likely not properly evaluated as far as company growth because it's already there. So it wouldn't pick up very many additional companies that are failing. It more identified the companies that already failed.
So a 30% threshold for the marginal operator category would be more targeted towards the operators and wells that you think are most at risk for being orphaned. Is that fair to say?
So that's what I was trying to say. Maybe I didn't do it very eloquently. I think after seeing the numbers and then seeing the C115 numbers, it's not showing what's at risk. It's showing what's already failed. So the proper number may be somewhere in between there.
But we don't know because the division hasn't done that analysis, we don't know what that is right now, right?
Well, we know the number that's already failed. And those were the numbers I showed earlier.
Now, on the C115 list?
On the C115 list.
All right. Now, on that C115 list, all we know is that those operators haven't been reporting production. And that happens sometimes. I have experience, right? Sometimes operators think that a consultant is filing the C115s and they're not actually. And then there's a correction that's made and those C115s get filed. And it's not because the well isn't producing, but it's because a third-party consultant may not be filing those production reports.
So those production reports are due 45 days after the end of the month. Those operators haven't reported any production since August of 2024. That would be an extreme failing. And following the NOV statutes that are in place of $200,000 per well or per violation cap, each one of those wells would more than likely hit that cap. Yeah. And you're talking those violations set on what was it, 3,000 wells or so? All of them could be potentially at that cap. Right. So that would be a big oops.
It would be a big oops. Now, but nevertheless, I mean, we don't know exactly the reason for why those production reports aren't being made, do we?
All I can say is that's a major failing on a company because that's one of the most fundamental things when it comes to being an operator is properly reporting your production.
So back to my question about the 51%. Somewhere between, 51% of operators and some lower number may be more appropriate, because you agree with me that the actual number of operators with wells at risk of being orphaned is something less than 51% of operators in the state. Agree?
I agree, and it's probably something over 25%.
So you agree also that there's been no study or analysis presented to the commission showing that increasing the marginal well threshold from 15% to 20% would prevent waste. Agree?
Agree by no parties that are involved in this case.
Same thing for a 25% threshold, right? There's no analysis showing that a 25% threshold is going to prevent waste.
Well, I think the 25% threshold I already showed was already out of compliance, but I would consider all of that waste if there's no production.
So the fact is, we don't know how high the division would need to go to set a threshold for marginal wells to know that the rule is going to actually prevent waste.
I think it's fair to say it's somewhere in between there, and it's up to the commission on what they choose to pick based off the data that was given.
Now, looking at Mr. Purvis's discussion about the 15% threshold. So he testified that he believed the impact was going to be, and I believe he used the word at least one time, minute, but he could not say what portion of the 2.3% of production, 17 million barrels of oil in 2024 production would be lost. Do you recall that discussion?
Vaguely.
Okay. You agree with me that he did not do an analysis and he couldn't say what portion of that affected or impacted production might be lost as a result of the implementation of this rule as proposed.
I would agree with that. And similar to Mr. Purvis, I couldn't tell you either, because that would be trying to anticipate what operators are going to do with their own production.
Right. So we don't know what the potential impact is going to be.
It could increase production.
And how would that occur? You think by incentivizing operators to go out and stimulate their wells?
Or just produce them. Again, it falls on this list if they have below 180 days of production. If they just produce their wells, that production may go up.
Isn't part of the incentive of the rule to encourage operators to plug wells?
Plug the wells that need to be plugged that are mechanically no longer available to operate. But if an operator can produce it, I think there's also a fair incentive that they produce it.
And again, there's been no analysis to discern what the ultimate impact is going to be of the rule, whether it's going to increase production or cause waste, right? Again,
I don't control an operator's business on what they choose to do, so I don't think you can do that study.
So nevertheless, that no study's been done, right? No analysis.
Asked and answered. I think that's the 5th time.
Yeah. Mr. Rankin, please move on.
All right. So, but what we do know from Mr. Purvis is that using a 30% threshold instead of 15% would impact only 33% of operators, correct?
Yes.
Okay. And that would be a decrease of about 18% in the number of operators impacted by the proposed rule, correct?
Correct.
Okay. And that 30% threshold would impact only about 0.6% of statewide production. Agree?
Theoretically, yes.
Okay. According to Mr. Purvis's analysis, right?
Yes.
Okay. So if I were to go back to the 2024 production numbers that I have, that I ran through with Mr. Purvis. And when I was discussing with Mr. Purvis, we did the calculation for the total oil production in 2024, multiplied it by 23%, which represents the 15% threshold. We got 17 million barrels, and then we calculated that value is about $1 billion, okay, based on the production for 2024. And if I looked at, and I go back to his screen, if I look at 30%, which is about 0.6% production, that gives me about 4 million barrels impacted based on 2024 production. Is that, you agree with that calculation?
I agree with that. That's what you did in your calculation.
Yeah. And that you agree that using that impact analysis from Mr. Purvis, that would be the estimated impact using 2024 production?
Potentially, yes.
Right. Based on Mr. Purvis's analysis, right?
Well, again, I don't know that we can say it's going to fully cost the state that 0.6% because of what operators do. They could always choose to operate their wells more. My understanding, based on prior OCD administrations, when OCD first took the inactive well list prior to me starting, but working with somebody that actually testified in that rule, production in the state actually increased after the first inactive well rule went into place.
So then if I do the same analysis I did with Mr. Purvis and looked at the value of that production, multiplied it using the same value of barrels dollars per barrel at $60 per barrel, it's about $266 million. Again, just doing the same analysis I did with Mr. Purvis, but using the 30% threshold analysis that he conducted. Do you agree with that calculation? At least that it's the same calculation, but using his different numbers for the 30% threshold?
Again, working with operators in the past, I say that your calculation's correct, but if it was that lucrative, I think more operators would produce more.
So I understand that's your view. I understand that's the division's view on how it may turn out, correct?
Well, I would say that's most businesses' view, is to make money. And if they think they can make money, they will make money.
So if I look at the potential impact, okay, and go back again, just thinking, keeping those numbers in mind, increasing the threshold to 30% marginal operators, increasing the 30% threshold, increasing the threshold to 30% from 15% would approximately reduce the potential impact on production by about 1/4. Is that about right?
I think I've answered this. I don't know that I fully agree because I don't know what an operator is going to do.
Again, just based on Mr. Purvis's analysis, right?
That's what Mr. Purvis's analysis shows.
Same thing with the dollar figures, right? It would reduce it by the potential impact by about
Objection. He's misstating Mr. Purvis's testimony, which was that those numbers reflect a ceiling.
Right. Mr. Rankin.
Well, the record stands for itself. I mean, I think that was the potential impact, the ceiling, the biggest impact I could have. I don't disagree. So the potential impact would be up to 17 million at 15% threshold, up to 4.4 million for a 30% threshold. Is that fair?
I think you had Mr. Purvis do the math. You're asking me my opinion. I don't know that I agree with that testimony.
Okay.
And that's what I'm trying to explain.
Very good. And you don't agree with it just based on Exhibit 16 then? On Division's Exhibit 16?
Oh, I'm sure the numbers are right, but as far as Exhibit 16 doesn't say how the operators are going to respond to this rule.
Right. And that's the issue, I guess. That's the question. Or what wells may have to be shut in, or what may not have to be shut in, right? We don't know.
Or what wells are even capable of production or not capable of production.
So increasing, but let me say it this way. You would agree with me that increasing the threshold to 30% would have a less of an impact on operators and the production in the state. Would you agree?
I do.
Okay. And so here, considering the impact of this rule, okay, wouldn't you agree that it might be prudent when starting out with a new rule that for the first time is proposing to prohibit operators from using statewide blanket bond that's mandated by statute under our view, and forcing them to pay $150,000 in financial assurance for every well they operate, and then not having done any real deep analysis to determine whether the rule will cause waste or impair quality of rights? Don't you think it's maybe at least prudent to start on the lower end of the potential impact?
Again, I think I explained, I actually expect this to be a negotiating factor back and forth, and 30% may be more prudent. We also expected operators to need some time to get to that point of evaluating their wells, getting them on production. That's why the caveat of the bonding not even going into place for 3 years is in there. Because it's going to take some time to properly identify, digest, and move forward. If you're asking if I'm okay with the 30%, I was looking anywhere between 15 and 30% as a gut reaction. The C115 that I showed earlier it may be a little less than 30%, but I was really looking at between 15 and 30%.
So, and then in addition to looking at, reducing potentially the marginal well threshold to reduce the potential impact when we're uncertain about what it's going to be. Another way to also lower the impact would be to reduce the definition or reduce the production portion of the definition for marginal well from 1,000 barrels of oil equivalent to 750 barrels of oil equivalent. Agree?
I haven't run the numbers, but that would be in line with the LFC put. And if I remember correctly, when we looked at those numbers, there's not a big difference between those two.
And if I go to Mr. Purvis's slides where he does an analysis that incorporates his logarithmic scale over here, and I look at where 2 BOE would fall, this is for the Permian Basin. If I look at where the 2 BOE would fall, that would capture up to the 25th percentile of wells in production, wouldn't it? That he identified as being the most at risk.
So I'm not 100% familiar with that graph, but that seems to be roughly correct.
Okay.
Mr. Rankin,
Yep.
5 minutes.
Thank you very much. And if I look at the same figure he did for the San Juan Basin, it's the same thing. 2 BOE would capture up to the 25% of the percentile of the wells and production that he identified as being most at risk for orphan wells, right?
Correct.
So if the commission were to play it safe and adopt a go it slow approach using a lower value for the marginal well definition, 750 BOE, and 30% for the marginal well threshold, doesn't the rule still have the presumption of no beneficial use that would function as a safety net to capture any wells that are identified specifically as at being imminent risk of being orphaned?
Yes.
Okay. And doesn't that provision effectively provide a fail-safe for the division to identify any individual wells that are at risk of being orphaned?
I believe so.
Okay. And that's a more targeted approach. Agree?
Yeah, it's just an alternative, but I see where you're going.
I'm not going to have time to get through all the other aspects that I had lined out for you, Mr. Powell, I don't think. But I'll see how far I can get in the few minutes I have left. Let me ask you about the TA status. As proposed, the rule limits the TA or temporary abandoned status to a period not to exceed 8 years based on a maximum initial TA period of 5 years and a one-time extension of up to 2 years. Is that your understanding?
Yes.
And OCD generally supports that provision as proposed, or are you open to modifications based on the testimony?
I think I already answered this with Nemogas Council. Okay. We're open as long as there's firm plans built into that.
Now, what about hearings? The rule proposes that each extension of a TA be required to go to a hearing before a division examiner. Based on the division's current docket capacity and pressures, in your opinion, does it make sense to require those extensions to go to hearing, or is it something the division can handle administratively?
I think the first 5 years, obviously, I think administratively is sufficient. After that, if there was a hearing and an operator brought a 15-year plan or whatever it was to the OCD division hearing, I think that'd be pertinent to give an entire plan and lay out criteria in that. I think testing should be at a 5-year interval at the most to ensure wells aren't degrading. But I think if you went to one hearing and laid out an entire plan of development for a set of wells and you're meeting those criteria, I don't see why you would have to continue going back to hearing.
And let me ask you this then on the hearing question, because it's not identified in the application or in the proposed rule, I don't think. Who would be given notice of an application for an extension?
Boy, it's been a long time since I've looked at notice provisions in the rule, so I wouldn't opine on that.
Okay, so if it's not clear in the rule and it's not clear who would be required to get notice, how is the commission to determine who?
Objection misstates the evidence. He didn't say that the rule was unclear. He said he didn't recall it.
That's right.
So, Mr. Powell, you don't recall what the rule provides, but you don't know one way or the other whether the rule provides or specifies who would get notice under a TA extension request.
That's one of the few rules I don't have memorized.
Okay. Would it surprise you that the rule as proposed doesn't actually identify who's required to get notice?
I don't know.
Okay. And how about for do you recommend that the division will authorize or the commission authorize parties that don't have standing to intervene in a TA extension case?
Not knowing the rule, I don't want to recommend what that would be to the commission.
But you're not clear yourself, based on the rule as proposed, who would be required notice?
I'm sure the rule is very clear, but I didn't prepare for that
Okay.
for testimony.
Please wrap up, Mr. Rankin.
Ms. Hearing Officer, I do have some more questions to walk through. I wasn't able to get through them all. If it's possible, I would ask for just a short extension. Give me another 10, 15 minutes to get through my questions.
So I didn't offer that to any of the other examiners, so I would feel funny about offering it to you.
I didn't ask for it either, but just I'll make the request. I don't want to defer, or if people think that my questioning is not, helpful, then I'm happy to hold off and pass the witness.
Thank you so much. I think to the extent that commissioners need more information through cross-examination, they're going to do that. Let's see, Mr. Maxwell, do you have questions of Mr. Powell?
No questions for Mr. Powell. Thank you.
Thank you. I don't know if Ms. Nanasi is on the platform. Mr. Moore, do you have questions of Mr. Powell?
I do have a few questions. Thank you, Madam Hearing Examiner. Good afternoon, Mr. Powell. My name is Richard Moore. I represent the Commissioner of Public Lands and the State Land Office in this proceeding. Thank you for your testimony this afternoon. I just have a handful of questions about the financial assurance required to be provided to the OCD. Can the State Land Office draw on financial assurance provided to the OCD if an operator has failed to properly plug and abandon a well on state trust land?
So the State Land Office cannot draw that directly. We've done work in coordination with the State Land Office, but State Land Office wouldn't have access to that, to my knowledge.
Okay. And can the State Land Office draw on the financial assurance provided to the OCD if there's surface work or remediation that is required at a well site that is on state trust land?
That would be the similar answer, that I don't believe State Land Office could draw that directly.
Thank you. So then, based on those answers, do you agree that for the State Land Office to be in the position to be able to access directly access financial assurance to plug wells or address contamination or conduct other surface work on state trust land, it would need to require its own financial assurance separate from that provided to the OCD?
I think there could be some overlap between what State Land Office and OCD requires regarding some contamination and surface reclamation, but I believe there's also other reclamation that State Land as a surface management agency oversees that OCD would not oversee. So if a State Land Office needed bonding for that or something outside of OCD scope, they would need to require their own.
Okay. And are you aware of how many wells the State Land Office has forced to be plugged under its accountability and enforcement program?
I do not.
Okay. I believe that is, those are all the questions I have for you, Mr. Powell. Thank you for your testimony.
Thank you.
Thank you, Mr. Moore. Ms. Fox, do you have questions of Mr. Powell?
Ms. Hearing Officer, I have a few. Thank you. Good afternoon, Mr. Powell. My name is Tanis Fox. I'm a lawyer with the Western Environmental Law Center, and I represent applicants in this proceeding. Thank you very much for your testimony. You testified that you wish you would have termed the term marginal well differently in your proposal. And do you have another term that you would prefer to use, like low producing well, or you mentioned in your testimony this morning at-risk wells for plugging? Do you have another term?
I didn't brainstorm a term since then, but I think I would just stand that marginal is used in lots of different ways.
In 1915-25-8, which is the commission rule having to do with wells being, they're inactive for 12 months, needing to either be plugged and abandoned or go into TA status. Are you familiar with that rule?
I am.
And applicants and OCD proposed to change the time period within which a well must be P&A'd or go into TA from 90 to 30 days, correct?
That is correct.
And I believe you gave testimony on Friday that an operator has the 12 months and the 30 days to plan for what it's going to do with that well, correct?
Correct.
If under the rules right now, if an operator chooses to P&A its well, and are there circumstances under which an operator is going to P&A its well and that work takes more than 90 days?
I think if an operator is on site plugging the wells, there is a potential that it takes longer than the 30 days. I don't know if it's taken 90. I think we've had a few that have gone over 30.
And if an operator needed more than 30 days to P&A its well based on good cause, would OCD have the authority to grant that extension?
I don't know if we would grant an extension, but I think we could use our discretion to allow working with the operator. Usually if an operator is actively trying to comply with something, we don't pursue them for enforcement actions.
And has that happened in the past with regard to this provision when an operator is attempting to P&A a well?
I would say most of the wells in the ACOIs are some of that intent where we're giving operators longer than the 90 days to work through a plugging or a compliance list.
And same sort of question with regard to presumptions of no beneficial use provision in proposed 1915-25-9. Under that provision, operators have 30 days to rebut the preliminary administrative determination of no beneficial use. If an operator needed additional time beyond the 30 days and had good cause, would OCD grant that extension?
I would say as long as we're going back and forth, we probably wouldn't enter in a final determination until we've gotten all the information we need.
Turning to the time period within which applicants and OCD proposed that a well be plugged instead of stay in TA status, you stated that if you testified something along the lines of if an operator made a showing that it had a plan to use a well, you would be open to an extension, something like that.
Yeah, so my memory serves me. I believe there's been one operator that I can remember offhand that came with a proposal similar to that. It was actually Oxy, where they were planning on doing a CO2 EOR. They came in and based on building infrastructure for it, based on meeting specific thresholds, they were asking to extend TAs based on that plan. And that was a very specific plan, very specific deadlines, thresholds, and it made sense in that case.
Did you either hear Mr. Alexander's testimony on the principles that he would apply for an extension or read his principles in his rebuttal testimony?
I don't remember reading his principles in his rebuttal, but I did hear his testimony, and I think we're very similar in what we're looking at there.
Mr. Alexander testified that an extension, that he would be agreeable to that type of an extension or exception if the exception were limited in scope, say to EOR as one example, limited in time, subject to OCD periodic review, based on sound engineering, technical, economic, and administrative information, not based on guesswork, hunches, speculation, or the like, and that any such language would have to be carefully crafted to avoid any kind of loophole leading to abuse. Can you agree with, would you agree with all those principles?
I do and I believe that's something that should be presented at the end of the first 5 years, because at that point, the operators had 5 years to make an evaluation of that well to determine what the future of that well is.
Industry has objected to the definition that OCD and applicants propose with respect to beneficial purposes and beneficial use, and specifically object to the terminology prohibiting or stating that beneficial use does not include speculation. Are you familiar with that testimony?
I
Their
am.
objection.
I am, and I believe I addressed that earlier.
Did you ever read or were you present for Mr. Purvis's testimony with respect to a sort of a rubric that could be used to assess speculation based on the Society of Petroleum Engineers manual on the use of reserves, what can support, there's a category of reserves and how speculative and how certain they are to be economic?
I don't remember all the details of that testimony. I'm sure I heard it. I've been listening since it started. But I do believe that a plan is more than just looking at reserves, because as stated previously, I think there's times where you can still have reserves left in place and you don't have a well capable of producing those reserves any longer. So I think more than just reserves, I think an operator needs to plan of either repairing a well if needed, recompleting a well, EOR, whatever that be. It's more than just what reserves are left in place. It would be a plan to get to those reserves.
Mr. Purvis offered that rubric as a way, as either guidance or requirement for making a determination about whether a use was speculative. And so I was wondering if you could support that testimony or not.
It sounds like it makes a lot of sense. I don't remember that one to the fullest, so I can't 100% agree, but I think we're very near the same place where I think there's times where the speculation should be on whether it's successful, but not the plan to implement it.
And finally, there's been a lot of testimony from industry witnesses that the OCD and applicants' proposed rules will result in premature plugging and therefore waste of the resource. Are you familiar with that testimony?
I am.
What is your general response to that testimony?
Again, I think it's going to be on how operators respond to it. I think operators have the choice of producing their well more efficiently or plugging the well. And I think it'll depend on the condition of that well, because I don't see an operator plugging a well that they could produce beneficially. It's the wells that are having downhole issues that are going to incur additional costs, similar to what Mr. Wrinkle brought up, that aren't going to pay for that additional work that are typically going to be the wells that are plugged. If it's simply turning on a well onto production, then that production would happen.
Thank you for your testimony. That's all the questions I have.
Thank you.
Thank you, Ms. Potts. Mr. Tremaine, do you have redirect?
I do have a couple of questions, Madam Hearing Officer. Mr. Powell, you were asked a number of questions on cross about OCD's limited resources and implications regarding those resources for orders, financial assurance, forfeiture, et cetera. So I want to ask you a couple of questions about such orders. So you referred in your testimony to ACOIs, right?
Correct.
And would you agree that, just for the record, that stands for Agreed Compliance Orders for Inactive Wells?
Yes.
I believe we also referred to settlements of notices of violation, which often referred to as SFOs, stipulated final orders, correct?
Correct.
Okay. Would you agree that the first order provision in any ACOI or settlement document related to inactive wells is that the operator must plug the wells, correct?
Correct.
Okay. And would you agree that for the most part, those orders alternatively provide authority for OCD to step in and plug the wells if the operator fails to comply?
The current ones, yes.
Okay. Thank you. If an operator fails to comply with such an order, does OCD have a specific mechanism to go out and actually physically force the hand of the operator to plug the wells?
No, I think it's similar along the lines of bleeding blood from a turnip.
We can get an order that says you have to plug the well. We can get a court order that says you can plug the well. We can issue a settlement agreement that says you have to plug the well, correct?
Correct.
But what happens when an operator doesn't comply with any of those things? Those wells go on the moss?
The wells go on the moss, OCD plugs it, and if OCD thinks there's any way to get anything back out of the operator, they can sue the operator, they can forfeit the bonding. I can't think of any cases where OCD actually sued the operator because they didn't think there was anything to get at that point.
As part of your job, are you regularly involved in the negotiation and negotiated terms of the settlement agreements that I've referenced?
I am.
And in your opinion, has OCD made every effort to define reasonable compliance terms for ACOIs and stipulated final orders that allow an operator to come back into compliance?
I have, and actually typically those timeframes, those processes are negotiated with the operator on what the operator feels that they can do. We look at what they stipulate as their availability to plug things or availability to return to production. And so that time frame is negotiated directly with the operator. I would say at the end of the day, all of those agreements are with the thought process that the operator agreed to those timeframes as far as getting compliance.
Despite the negotiated nature of those settlement agreements and OCD's willingness to work with operators, you agree that a substantial percentage of those settlement agreements have resulted in wells being placed on the moss and plugged by OCD?
Yeah, I would say there's lots of good intentions, but at the end of the day, not all of them are successful.
Okay. I want to move on and ask you a couple questions about Mr. Cloutier's cross-examination. You were confronted with a series of invoices from OCD's contract plugger, Drake. Do you recall that?
Yes.
Okay, so some of these average plugging costs have been bandied about. So I want to clarify that the $163,000 average plugging cost, that's for OCD conducted plugging during the fiscal year 2024, correct?
Yes.
Okay, and do you recall from those invoices that you were confronted with that the dates on those invoices were 2022?
Yes.
So would you agree that any issue with those invoices would not be reflected in the fiscal year 24 average plugging cost for OCD?
Correct.
Okay, were you confronted with any examples from 2024?
I don't believe so.
Okay. One moment. There were a number of questions that were posed to you regarding or suggesting that OCD is not forfeiting substantial FA or particularly financial assurance that resides in the form of $250,000 blanket bonds. Do you recall that testimony?
I do.
Madam Hearing Officer, I'm going to share screen and share for Mr. Powell the OCD exhibit number 29, the financial assurance report.
Thank you.
So, Mr. Powell, this is already entered into evidence and admitted, but this is the financial assurance report. You had this pulled in preparation for the hearing, correct?
Yes.
Okay. And do you agree that column G here is the base amount for financial assurance that says the amount of the bond that's listed in OCD's system?
Yes.
Okay. And from your testimony earlier, you had indicated on these sheets that these are filterable, correct?
Correct.
So if we, is it going to work? What is going on?
I will say sometimes if they're restricted, the filterability is affected.
Yeah, let me pull up let me pull up a local copy. The one that
And typically, while you're pulling that up, we restrict those so the core data can't be changed. But if other parties wanted to take that information, it would be a simple copy and paste into another Excel sheet to then filter.
Thank you. And that is, I believe, what's going on here, because that's from the file. So that one was protected. I'm using a local copy from my desktop. All right. So the back to the base amount in column G, if this is filterable, we can turn off all the filters for the small bonds and look at blanket bond amounts. So I'm clicking on 250,000, 500,000, and 1 million, which are the blanket bond amounts. And these are the current blanket bond amounts that are payable to the OCD, correct?
Yes.
One moment. When you review this list, are we able to identify any financial assurance that is attributable to an operator that has been deemed out of compliance with inactive wells and for which OCD has plugged their wells?
So to identify that, you would look at the bonding amount that has been reclaimed, I believe, or redeemed.
Is that sum of redemption in column H?
Yes.
I remove the zeros here. So there's one blanket bond here, which is showing a redeemed amount.
Yes. And I think part of your problem finding, looking at operators to see if we redeem $250,000 bonds is because most of the operators in Moss did not have the $250,000 blanket bond.
Yeah. So my line of questions here is just, is there anything else that you would add that would be, beneficial in reviewing this sheet to allow the other parties to look and see if there were actually any payable blanket bonds under wells subject to OCD enforcement?
So if you wanted to filter this, let's just pick one of them under operator name, pick Canyon. I think you still have another filter on because I see from line 1 to 38, it skips. So if you clear all your filters.
This is why I said earlier, we don't want me doing Excel changes here so this is a better way. Thank you for that, Mr. Powell. Okay, so here we have all of Canyon E&P companies, any company's bonds. So if we look at
So if you look at G and H, that shows the base amounts. Again, that's what I referenced in my testimony, the 6,000 per well individual bond. And then it shows the redemptions on the bonds that OCD is currently redeemed and the plans to redeem more. That 50,000 at the bottom box that you see, so if you unhighlight, it'll pull up Canyon's blanket bond. So you can see in Canyon specifically, OCD has already redeemed the blanket bond for Canyon. So the only thing that OCD can now pursue is the individual well bonds.
Okay. And to your knowledge, are you aware of any currently payable larger blanket bonds that OCD is able to take action on?
Not that I'm aware of offhand. Typically, the blanket bonds is what OCD starts with as far as trying to redeem the bonding. There may be one on some of the most recent pull, maybe like an Energy Acumen, just because that was a more recent plugging. But usually the blanket bonds are the first thing we go after because they're so small in comparison to plugging. Even if we pursue one individual well bond or two, then we then attach the blanket bond with those pools and pool that as well.
Okay. Mr. Powell, I'm going to move on. You've been asked numerous questions about prevention of waste and correlative rights. As Deputy Director, are you comfortable stating that it's also the division's job to manage the reclamation fund?
It is.
And to plug orphan wells using whatever's available in the reclamation fund?
Yes.
Is it also the division's obligation to regulate, to require the remediation of releases, specifically environmental contamination?
Yes.
And are there also similarly provisions that protect various different types of water resources in the state from impacts of oil and gas development, production, et cetera?
Yes.
Okay. Do you recall the waste rule, parts 27 and 28?
Yes.
Okay. Is under the rule, and in your opinion, is venting of natural gas a waste?
If it's venting natural gas for no beneficial purpose, then yes.
Okay. What percentage of wells monitored for methane or natural gas venting or emissions as part of the orphan well program are leaking methane?
60%.
So orphan wells are causing waste through the venting of natural gas.
On 60% of them, yes.
Okay. After going through this hearing, reviewing the testimony, listening through the hearing, do you have any recommendations for the commission regarding the production threshold criteria for the presumption of no beneficial use? I'm also going to ask you about marginal wells. Let's start at presumption of no beneficial use. Do you have any recommendations based on the record of hearing for the 90 BOE and 90 days of production?
You know, I think there was a lot of discussion, a lot of questions that were asked about tracking production days, those kind of things, whether it's useful, whether OCD has done it in the past. And 90 BOE is extremely low threshold. It's less than 1 barrel of oil per day. So I think that would be a hard threshold to make if an operator was really utilizing their well. So I think, as in my rebuttal where I recommended things could happen, I think removing the days provision of the 90 BOE would probably be sufficient. And then if the operator wanted to come in and justify why they weren't producing, they could always do that as a presumption of no beneficial use. It would move that threshold from an operator or from an OCD threshold and enforcement tool to an operator required threshold.
All right. Does that address any of the concerns raised during the hearing or some of the conflicting testimony about inconsistencies in days reported for production by some operators or operator practices?
It would, and I think Mr. Purvis's scatter plot, when the commission looks at it, I think is a good illustration of that, because there's some wells that have very, very low production, like just a few barrels, but are showing 200-300 days of production. I think unless there's an issue with that well, that's probably just an operator filling a box without looking into it further.
I have the same question for you. We've heard a lot of discussion about the marginal well definition of 1,000 BOE and production for 180 days. And we've had all of the and/or discussions. Is it, as we wrap up, this is my last question, is it the division's position that it's still appropriate to maintain both the 1,000 and I mean, very, very clear, and 180 days of production there? How do you respond?
So I think at that level of well, I think having the 180 days is beneficial to have that provision to show that an operator is legitimately trying to produce their well. It's a 50% provision. I think there's probably ample evidence that decline curves are stabilized near the end of a well's lifetime. So even if it's a low producing, if it's a constant production, then that's something that should be considered. Whether it's 1,000 or 700 as LFC recommended, I'm not going to opine on one of those or the other. I think they both accomplish the goals OCD is looking for in what they're looking at, but I think the 180 days is a good test. If a well can produce 50% of the year or just over 50% of the year, then an operator is legitimately trying to produce that well.
Madam Hearing Officer, I pass the witness. Thank you.
Thank you, Mr. Tremaine. Commissioner Mpoma, do you have questions?
Yes, I do. Thank you, Mr. Powell, for your testimony today. Is it possible for us to get the comparison of the rules up so to be much easier for me? The PowerPoint?
The visual aid, Mr. Powell's first visual aid.
Yeah, the ones that he's comparing works proposal and OCD's comments.
I will put that up in one moment.
Appreciate that. Yeah, I want to start from slide number 5. Thank you. So, Mr. Powell, there has been a lot of discussion about the speculative purposes, and I've asked a lot of questions about that. There has been a lot of discussions too about that. But my question to you is, have you looked at NIMOGA's proposed definition for beneficial purposes or use?
I may have, but I don't remember it offhand.
Okay.
I apologize.
I'll read that. So that one was a rebuttal testimony from the applicant. So out of 266, I'm going to read from page 53. So I'll just read that. So there was a question to the applicants, and they provided this definition here. So beneficial purposes or beneficial use means that a well is being used or is reasonably expected to be used in a productive, operational, or regulatory capacity consistent with its intended purpose. This includes, but not limited to, production, injection, monitoring, regulatory compliance, or participation in reservoir management, pressure maintenance, or infrastructure optimization programs. That is their first paragraph. And they do have another paragraph saying, in determining whether a well is being used for beneficial purposes, the division may consider operational records, production, oil injection history, regulatory filings, and operator submitted plans or supporting documentation. The division shall provide the operator reasonable opportunity to demonstrate beneficial use prior to making any contrary determinations. What is your assessment of this definition compared to what the applicant and OCD has proposed?
I think that adds a lot of variability and vagueness. In the first part where it said reasonably expected to be used, I think every operator, if you ask them, is expecting to use the well at some point, but how they plan on doing that or what time frame is always up for subject. I've seen wells that have been TA'd for over 10 years. If you ask the operator, they state, I'm still planning on using that well. So I think that adds some vagueness to it. I think towards the end, in Nemogas, they said before a determination is made, the OCD has to ask for all that information before any determination is made. I think by OCD making the preliminary determination, it incentivizes the operator to bring that to the OCD instead of the OCD having to request that and get it from the operator beforehand. I think that process works a lot smoother as currently submitted.
Now, so there was a discussion about the speculative purposes tied to the petroleum resource management system. I went back and forth with Mr. Purvis on that because I was a little bit confused about how you can connect that PRMS, classification to, let's say, a well. And you touched on that again, where you said reserves, there might be a reserves there, but probably the well cannot produce. So do you believe that that assertion of the commission, more or less, or the OCD tying some rubrics to the PRMS completely, let's say, appropriate?
I think the way the division in the application, it's set up where the division can consider basically anything after the preliminary is sufficient, because if the operator comes in and shows well history, shows productive purposes, those kind of things, I think that's important. It's not in this definition here, but it's in how it's used in another part of the rule. I think that's something that the commission or the division could look at, but I don't think that's the sole thing that they look at, because there's lots of different variables that could go in with each well.
So just focusing on the applicant's definition, without the speculative purposes, you believe that OCD do have a strong understanding of this provision, and they are they are in a strong position to implement this.
So I think the speculative purposes adds a little bit of clarity that it's not that pie in the sky type speculative purpose. If the commission wished to strike it, they could strike it, but I think that's what it's to avoid, because there's always going to be speculative results of a plan. I think what the applicant is trying to do here is not to get hypotheticals that are not well thought out in that ask.
So let's move to slide number 8, the definition of marginal wells. So I just want to confirm, based on the redirect, it sounds like OCD position is still between 750 and 1,000 BO, but you want us to keep the 180 days intact. Is that correct?
I think if an operator is legitimately trying to produce as well over 50% of the year or right at 50% of the year and is successful with that, I think it's beneficial to the state. So I think the 180 days, especially when you're looking towards those end of life wells that are on stable decline curves, those kind of things, could still be beneficial to the state.
Thank you. Let's go to slide number 17. So in your direct, you said something, and I quote, as long as an operator is producing a well more than 180 days, and I'm sure probably said it now too, they don't need to put up the requested bond. Do you recall something like that?
I do.
Okay. So then my first question to you on this is, let's say on the number 3 item, why should we not strike that? Because with or without that, your assertion is correct that as long as we've identified wells to be marginal wells, all of these will be bonded.
So 3 is for an entire operator's portfolio. So if, say, that over 15% of their wells, they don't produce at least 180 days, again, that would be over 15% of their total wells. If over 15% they're not producing at least 180 days, that shows that operator's operating at a high risk. So that provision is to bond all their wells because they're operating in a risk environment instead of just bonding the particular marginal wells.
Yeah, but the problem was that, this 15% will also impact active wells. So based on the quote that, I just read to you, you were saying that if a well is not marginal well, they shouldn't be subjected to this 150 bonding.
So they wouldn't be subject to the 150 on an individual well basis, but operators operating at a high percentage of those well types are operating in a risk environment. So like the C115 list I showed, they're 100% in that. But you can have operators that we've seen are operating at a high number of risk wells because those operators are taking individual wells to failure. This would allow, as that company is taking those wells to failure, to act on all of their wells sooner in a portfolio rather than later.
So definitely OCD would like some type of number 3 to be in the room.
Yes, whether it's 15% or up to 30%, I would leave that to the commission, but I think there is a number there, whether if they're operating 1 in 5 wells or 2 in 5 wells, whatever that comes out to. If they're operating that high of a percentage of their wells in that high risk environment, they, as OCD sees that, they're operating on the verge of failure potentially.
Yeah, and you touched on that. You really wanted some discussion back and forth with the with operators, and it sounds like the attorneys are proposing some in the range of 30%, and I believe you also support that.
I think wherever the commission lands between that 15 and 30%, or and those other percentages in between there on Mr. Purvis's slide, that would be up to the commission.
And based on Mr. Purvis' analysis, OCD will still achieve the objective if that 30% is implemented.
Yes.
Thank you. Let's go to slide number 20. So on slide number 20, so if you read through it, I don't see any timeline. So is there any time frame for this provision? And do you need to add any timeline to this provision for more clarity? Or probably not needed?
I believe it's in another provision, so I don't believe it's needed because as written, they have 3 years to comply with the bonding provision unless they go to transfer those wells, and then those affected wells would need to be bonded. So I don't believe they need it here.
Let's go to slide number 21. So there has been a lot of discussion about, giving some kind of discretion to OCD on some of the exceptions that we've been discussing here. So I just want to read something here just to confirm that we used, so I'm reading from the first line, on January 1, 2028, and on January 1 of each successive year, the division may adjust the financial assurance. So the use of may, do you believe, gives OCD that room in terms of the discretion to increase or more or less decrease the financial assurance?
Yes.
Now, another question is, will OCD consult stakeholders prior to the increment of the cost, or is it just going to be a unilateral decision by OCD?
The way I would see this occurring is OCD would do an evaluation of their plugging costs before that, because as the LFC provision we went over stated, it's for actual cost of plugging the well. So if costs continue to go up as they have been, and the consumer price index goes up, then OCD would look at needing to increase that bonding amount. If costs for plugging go down or stay the same, even if the price index goes up, but costs don't go up, then I don't see OCD using this provision because of the overall statute. It's supposed to be based on what it actually costs to plug a well.
Yeah, and I think the applicant did a great job really establishing why the 150,000 is the actual cost to OCD and not necessarily to the industry. So I think that one is much clearer, and I will not ask you any question on that. But let's go to slide number 25. So the slide number 25, does this provision impact working interest owners? Is just strictly going to be on operator on record?
I guess I missed the question. I apologize.
Okay, so the question is this provision, just going to impact only the operators, or is going to be going down to the working interest owners for that particular well?
Commissioner, if I may. So in talking about the implementation of FA dates and this provision, I think there's later versions in the rebuttal testimony. So I just want to make sure we're clear on those two sections, that those were updated. This was, I believe, updated in a later submission, which number I don't have at hand, that changed that language. We talked about that. And so that's going to be an important distinction.
Okay.
And then the effective date was changed from January to May in OCD's proposal. I don't have those up, and sorry to interject, but I just want to make sure that that's during the course of the hearing, I think, or during the course of direct to rebuttal testimony, those have been updated.
But I think I can answer your question, whether it's just the operator or if it extends down to working interest owner, those kind of things. Historically, we have just held the operator responsible. There's actually even a 25% clause when an operator registers. This would be giving more of a certification, so it'd be more of a positive type interaction. But historically, the division has not pursued working interest owners involved in the well, as there can be few or several. We look more as the operator of record to OCD. I know State Land Office, others look more at the working interest owners and leaseholders and those kind of things, but that's not something the Well Conservation Division has typically done.
Yeah, so if working interest owners are not really part of that, don't you believe that we've not really fully assessed the risk? Because they might be working interest here, but they might be more or less not necessarily, but they might be more or less combining efforts on other wells, and that has this kind of issues, and we'll probably not fully address that.
I don't know if we've addressed that. I think as far as OCD is concerned, we always looked at the operator. And I think if the operator is negotiating with a working interest owner that's causing them issues, that may be something the operator self-regulate and not work with those working interest owners in the future. But if the commission would like to explore that, they certainly can.
Yeah, thank you. And thanks to Mr. Shaman for pointing out that. I remember May 1, but I was just focusing on this one line by line. So thank you for that correction there. So let's go to slide number 26. So on slide number 26, I know there were a lot of discussions going back and forth on this one, but I just want to be clear. How is OCD going to implement this in terms of verifying operators' operations in other states? Do you have any mechanism in place that you're going to use, or is going to be provided by the operator itself?
I believe we've seen this as being provided by the operator, or if there's questions and discussions, asking the operator for additional information.
So you're going to rely solely on the information that the operator provides to you. But what about if they are missing some information or they are hiding some information? Do you have any mechanism to really prove that they are giving you all the true statements or information?
If we feel that they are hiding information, OCD does have subpoena authority to get additional information. If that's your question.
Yes. But that is, you need to have a mechanism to know that they are hiding information. So that is my question. Do you have that mechanism?
I know our legal group has reviewed corporate filings and different things in the past. So if we have done some searches of companies and corporations, we have reached out to other states to see if they're having similar problems with the specific operator that they're doing work in. So we have done some of that.
So let's go to slide number 33. So you made mention that the 30 days and the 90 days was one of the items that you really wanted industry feedback on. But it sounds to me that you explained clearly as to why you prefer 30 days, because now everything is filed electronically. Do you still want the commission to probe, to get some consensus from the industry on this 30-day?
I may have misspoke. I don't believe this was one that we were looking at needing back and forth with industry because the 30 days is on top of the 1 year. So once a well is having issues, if operators start prudently planning on that well's use or production at that point, they've got essentially 13 months to look at it. But I would leave this at the discretion to the commission because in the life of a well, an additional 60 days isn't that much.
Let's go to slide number 34. So we've discussed a lot of these exceptions that OCD might implement, and it sounds like OCD is in agreement to that, but it's not clearly stated in the rule. So is it possible for OCD to provide some guidance, let's say in their closing, for the commission's consideration with regards to how we can frame the exceptions into the rule if necessary?
I think that would be appropriate to do in closing. It may be the commission may want to also ask for a proposed red line from each of the applicants as part of the closing. But that's definitely something the commission could ask for.
Appreciate that. Let's go to slide number 37. Okay, so the provision number 1, documentation demonstrating the well is reasonably projected to produce in paying quantities. Can you elaborate a little bit on how you intend to implement this? Is it going to be based on the 90 barrels equivalent and then the 90 days, or how are you going to implement this?
So this is a preliminary determination for non-beneficial use. So this would be off my recommended 90 BOE, which also had the 90 days attached to it, but I'm recommending taking the 90 days off and just keeping it 90 BOE. So any of the wells that they get a preliminary determination of non-beneficial use based off that 90 barrels, the operator then could bring this documentation to OCD and make a case for whether or not they feel that well is still being used in a beneficial manner.
And will this apply to on slide number 38? So you do have economic data in there too. Will your explanation also apply to the requested economic data?
The economic data, yeah, it would be the operator making a case where that well is still being used in a beneficial way. That would include any economic data that they wanted to show, showing that it's producing in paying quantities, showing where it's capable of production and doesn't have a downhole issue, or if it does have a downhole issue, how they plan on repairing that and still having a productive well at the end of the day. It's really giving some high level requests and asks, and then up to the operator to make that demonstration based on those high level requests.
Let's go to slide number 39. So I highlighted any interested person may intervene under the rules. Can you explain a little bit that provision?
I believe that provision was written in so members of the public, if a well was being requested at TA, any person could intervene in that, even if they're not an owner of the well, working interest owner, those kind of things. I didn't write that, so that's not something that I'm as familiar with.
Okay. But I'll still ask you one more thing there. So in the last paragraph, or let's say the last 3 lines, an extended term shall not exceed 2 additional years. So the use of shall means that's it, right? And we've talked about the potential flexibility that we want to provide to OCD on this. So would you be okay if we change the shall to may not, at least to give you the room to implement the potential beneficial use to cover some of these exceptions?
Or even rephrasing that the extended term may not, or may have to meet these particular items. I think Welk did a good job of elaborating on those, but I think after that first 5 years for additional extensions, just the operator having a solid plan of that well's development in the future and proposed timelines is critical on the continuation of TA.
So would OCD provide some good sentence on that to really clarify this?
Certainly.
Okay, thank you. And the same thing. So let's go to slide number 40. So the second line, wells that have been inactive for 3 or more years are not eligible for temporary abandonment status. So on that one too, I was thinking, can we more or less put in may not be eligible to still give you the flexibility?
You can certainly do that. The intent of this one, because we have operators that unless we catch them doing something, they're not going to do it, unfortunately. This was to encourage them to be more proactive in coming to the division and requesting that TA before they're significantly out of compliance, where if they come to us within those 3 years, which roughly 2 years of that would be non-compliance. But if they come to us before that 3 years, then we would work with them. But if they're essentially avoiding their duties as an operator for 3 years, that it would just be ineligible. But it's certainly up to the commission if they'd like to change that.
So it sounds to me that you believe that as it is written now, it still provide OCD the flexibility to implement this rule.
Yes.
Okay, thank you for that. Thank you for your time. And now I really have a clear understanding and know the questions that I'm going to ask the operators. Thank you, sir, for your time.
Thank you, Commissioner.
Thank you. Commissioner Bloom, do you have any questions of Mr. Powell?
I do, yes, thank you. Pull these up real quick. And excuse me for not being there today. I'm still under the weather, the flu or something. It's been a bad run. Mr. Powell, thank you for your time today. We've had you up there for a while. Just a fundamental question. Can OCD call multiple bonds if one bond doesn't pay for a single well's P&A cost? So let me give you an example. Imagine that we're under these rules as proposed, and company A has 5 wells bonded $150,000, and the PA costs for well 1 are $250 or $250,000. Can the OCD call more than one bond to cover that, or only the one bond for that single well?
So the way I would see it in this circumstance is OCD would first call the single well bond. If that bond is not sufficient, it would then call the blanket bond as an umbrella type bond in that scenario. And if it's not sufficient, then obviously we would look at potential other routes as needed. But we absolutely have and would look at using both bonds, the single well and then the blanket bond if the single well was insufficient.
Okay, thank you. That's helpful. Mr. Moore asked some questions of you about the land office, and I think Mr. Rankin may have touched on this as well, but do you know if the OCD notices the land office on TA extensions?
I don't believe that. I don't believe as written currently OCD does, or that it's required to.
Yeah. Would that be something you would have issue with, say a requirement that OCD notice lessees in the land office?
As a mineral owner, if they have a solid plan, I would think that an operator would be working with the mineral owner, similar with BLM or SLO, on a long-term plan, especially if they were pursuing things such as EOR, those types of applications, to make sure their lease agreements complied with that.
I can tell you that many times there is not coordination between operators and lessees in the land office. And so that's why I'm asking, could there be notification from OCD to the land office on TA extensions?
I think there definitely could be, and I think that's something, especially if it goes past that first 5 years, and they're looking at a longer term plan, that I think could be prudent.
Okay. I've mentioned this a few times in other cross-examinations, but one of IPNM's witnesses' comments, and it might have been Mr. Ezel, was that bonds, or perhaps Mr. Emmerich, bonds can't be canceled once required for a marginal well or non-beneficial well. Is that your understanding of this rule, that once once a well has been restored to production above that of a marginal well, that the bond can't be dropped?
I don't think that's ever been our look at a individual well bond, that if an operator then achieves compliance, that we don't release. So I see continuing that even with this rule. If an operator, say, decides to use their well 180 days where they previously weren't, we would then release that bond.
Okay. I was going to ask you about the 180 days and 1,000 barrels, but Dr. Mpomo went over that, so I appreciated your discussion of that. Thank you. Let's see. Yeah, and I'll skip my question about 30 versus 90 days of notification. Regarding differences in plugging costs, I talked about this a little bit earlier. I'm questioning whether we can even compare OCD P&A costs with those of industry. We might be looking at apples and oranges here, where operators that are engaged in P&A are companies that are, following the law, have intended to follow the law and our OCD regulations, and have kept their wells in some sort of working order. Whereas when companies that are orphaning their wells, these might have been folks on hard times that have neglected regular upkeep, or have left, orphaned their wells many years back. And so you have two totally different classes of wells. Can you speak to this?
Yeah, I think I hit that fairly extensively in both my direct and rebuttal. I believe operator plugging and OCD plugging are definitely apples to oranges when you're looking at it. They're all wells, but the conditions of the wells are significantly different. The period between last production and plugging is significantly different. Most operators, if their well fails and they're prudent, they'll either plug that well or do a workover on that well at that point. But a lot of times the wells we're seeing is that operator takes that well to failure, complete failure, and then they leave it there until enough of their portfolio reaches complete failure that OCD takes action. So those wells are sitting out there for years, if not decades, being unplugged and unresolved. And during that time, you still have, because you're not using corrosion inhibitor, you've got corrosion, you've got scale, you've got all kinds of things going on in that well. And if you have a casing leak, you could have an influx of water, you could have an influx of sand, you could have a lot of different things going on in that well during that neglected period.
Yeah, thank you. And then finally, you spent some time discussing, your views on the oil and gas, NMOGA and IPNM not engaging with applicants and the OCD on this rulemaking. I think we're in agreement that the first draft notice from the applicants was published here April of 2024. Is that correct? About 18 months ago?
That sounds correct.
Yeah. So that would have given parties plenty of time to come to the table, look through this, and discuss if they thought there were issues that could be worked out, right?
That's the stance OCD took. I don't remember seeing the rule application before it was filed. And once it was filed, there was some things that OCD requested of the applicant to change and modify. And they were very receptive to those changes. And there was some definite changes that OCD recommended that the applicant took in their rulemaking process. And there was even changes that when Oxy approached the applicant and then the OCD, that changes were made in looking at it. So it's definitely something OCD, once the application was made, pursued.
Yeah. When I read through IPA&M's witness testimony and rebuttal, I saw a good number of recommendations that some of the witnesses were making. And there are some good questions as well. But on the recommendations, I did not see any red line of the applicant's proposal. I didn't see backup data for those recommendations that we could act on. Mr. Powell, have you reviewed that testimony? Do you have any reaction?
I have reviewed a lot of it, and I wouldn't say exhaustively. So if there may be something in there I didn't catch, but I didn't see any recommended red lines, suggestions, those kind of things.
Okay. Mr. Powell, no further questions. Thank you for your time today.
Thank you, Commissioner.
Thank you. Chair Chang, do you have questions?
I do not at this time. Thank you.
I have just one. How many barrels did you get out of that leaker next to the Pecos?
So since Friday through the weekend, as of this morning, I believe it was just under 6,000 barrels that were released.
Thank you very much. All right. Any reason not to excuse Mr. Powell? Thank you very much, Mr. Powell. Let's take a 15-minute break. That brings us back at 3:05. And I believe we might be hearing from Ms. Marks next. oop, wait. The chair will have to come in. Let's come back after our break, please. I believe now we turn to the State Land Office for Mr. Moore and Ms. Marks. Mr. Moore?
Thank you, Madam Hearing Examiner. Good afternoon, Madam Hearing Examiner and members of the Commission. My name is Richard Moore. I'm representing the Commissioner of Public Lands and the State Land Office. I just have a short opening statement. Before we proceed to the direct testimony of Ms. Marks, the Commissioner through the State Land Office manages millions of acres of state-owned land across the state as state trust land. There are over 5,000 active oil and gas leases on that state trust land, with tens of thousands of oil and gas wells on those state oil and gas leases. While the Commissioner and State Land Office regulate the leases to state trust land, the Commissioner and State Land Office do not directly regulate wells or the transfer of operatorship of wells, and has entered this and as such, the Commissioner and State Land Office have entered into this proceeding to provide support to the applicants and their proposed amendments to the regulations at issue, and provide the limited testimony of Allison Marks, the Director of the Oil, Gas, and Minerals Division of the State Land Office, with limited clarifying edits. And so with that, I would turn to Ms. Marks' testimony.
Okay, thank you. Is Ms. Marks on the platform?
I am.
Hello. Let's get you pinned here.
I'm okay with not being pinned.
Oh, I saw her. Yeah, there you are. All right. Would you spell your first and last name for the transcript, please?
Sure. Allison, last name Marks, Marks.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Moore.
Thank you, Madam Hearing Examiner. And Ms. Marks, I know you just said your name, but could you state your name and your position at the State Land Office?
Sure. Allison Marks. I'm the Director of the Oil, Gas, and Minerals Division at the State Land Office.
And did you prepare written direct testimony that was attached to the Commissioner of Public Lands pre-hearing statement in this matter?
I did.
And are there any corrections or clarifications that you would like to make to that direct testimony?
There are.
If you could go through the corrections and clarifications that you would like to make.
Okay. So there was a typographical error where there's a reference on, I believe, let's see, on page 3 of the written submittal under direct testimony of Allison Marks. It references 19.15.12.13b, and that should be a reference to 19.15.25.13b. So the 25 should replace the 12. And I'd also like to make, to remark on 2 points of clarification. Under 19.15.9.8 C5, the current proposed application, if I tracked everything correctly, because there were a lot of applications, I feel like, and we're pretty understaffed, and I was doing other work this whole time. But it lists limited partnerships, and it would be more inclusive to list both limited partnerships and limited liability limited partnerships. And that would seem to align with 54-2A-108 of NMSA. If you don't mind me for a second, 54-2A-108 of New Mexico statutes annotated says, the name of a limited partnership may contain the name of any partner, because each partnership that is formed pursuant to the Uniform Revised Limited Partnership Act or that elects to be governed by that act shall be a limited liability limited partnership. The name of such limited liability limited partnership shall contain the phrase limited liability limited partnership or the abbreviation LLLP or L period L period L period P period, and shall not contain the abbreviation L period LP or L period P period. And then subpart B says, subject to the provisions of subsection F of this section, the name of a foreign limited partnership that is not a limited liability limited partnership shall contain the phrase limited partnership, and that goes on. So that is the suggestion, to include the point limited liability limited partnership. There's a little bit of ambiguity in under this statute of 54-2A 102. So I think it's better to be more inclusive than under inclusive and erase any sort of ambiguity under that law. And then since submitting my direct testimony, I noted the definition of approved temporary abandonment, along with, I hadn't seen this at the time, there's a definition of expired temporary abandonment, includes the words in the definition of, quote, a well status of inactive. And it may be better to eliminate that phrasing and insert a time period of non-production, since OCD doesn't actually have a well status of inactive on its OCD permitting page. And in particular, with expired temporary abandonment, this could cause great confusion. At the land office, we are always looking to see if a lease is in good standing. So when we look in OCD permitting, there's not actually a well status of inactive. A well can be in the status of active for 10 years, but it hasn't, it'll say active, but the well has actually been not producing for 10 years and it will say active. So, so I think that's just a better, it would be better in the rule to actually put a time period. That is it, Mr. Moore.
Thank you. And is your direct testimony, including the corrections and clarifications that you just went through, true and correct to the best of your knowledge?
It is.
And do you adopt your direct testimony with including the corrections and clarifications you just went through?
I do.
Thank you. At this point, Madam Hearing Examiner, the commissioner would move to admit Ms. Marks' testimony as attached to the commissioner's pre-hearing statement into this matter.
All right, I'll pause for a moment in the event there are any objections. Thank you. It's admitted.
And rather than provide a have Ms. Marks provide a further oral summary of her testimony, we would submit her testimony as written, as submitted, inclusive of her corrections and clarifications just made, and allow cross-examination should the parties request.
Thank you, Mr. Moore. Mr. Cloutier, do you have questions of Ms. Marks?
Very few questions, Madam Hearing Officer. Good afternoon, Ms. Marks. As you know, I'm Andrew Cloutier, Hinkle-Shaner. I'm representing IPA, and I'm here today. I've coordinated with other industry counsel, and we had a few questions for you, and I was the one who drew the straw. In 2018, you were the Deputy Director of the Oil Conservation Division, and you testified to the Commission about the contents of the financial assurances rulemaking that was proposed at the time, correct?
That's correct.
And you gave truthful testimony that was accurate to the best of your knowledge at the time?
That's correct.
The commissioner and the state land office has recently announced some, I don't want to mischaracterize it, but examining state land office bond requirements, and there are some listening sessions or public meetings on that scheduled for mid-November. Did I get that correct?
I can't, I know the commissioner has announced some meetings that are coming up. If it says mid-November, that sounds about right. I know there's some in the end of this year. I don't, I'm not probably the best point person on the bonding rule public comment.
You gave me the information I was looking for. I apologize for being so precise about the dates of the public meeting. Is it possible that the commissioner may adopt rules concerning bonding of state leases that, if this rulemaking were adopted, would result in double bonding?
I believe that the commissioner is looking at bonding state leases as well as to make sure there's adequate bonding for land office leases.
Okay. And last question, has the land office made any review or analysis of the potential economic effects of this proposed rulemaking?
Not that I'm aware of.
All right. Ms. Marks, thank you for your time and appreciate your public service.
Thank you.
Thank you, Mr. Cloutier. Mr. Suazo?
Yes, just a couple of questions, Madam Hearing Officer. Ms. Marks, good afternoon. How are you?
I'm doing well. Thank you.
Excellent. I just wanted to clarify the question that Mr. Cloutier asked you, because he covered most of the questions that I had for you. And I just wanted to confirm that I guess the proposal for the bonding from the land office is on a lease-wide basis. Is that correct?
Okay, so I don't want to misstate anything regarding the bonding rule. I did not brush up on the bonding rule in preparation for this. So I believe the proposed bonding rule, I'm sorry. I believe the land office is looking at bonding for individual leases. I believe that is correct. Do you want to restate your question? I'm sorry.
Sure. And
you threw me a curveball there. I'm sorry.
No, and I wasn't trying to trick you. I just wanted to confirm. And the reason why I wanted that clarification is just so that the commission could be cognizant of the fact that there's a potential proposal from SLO that is lease-wide, whereas in this proceeding, we're looking at individual well types of bonding. Is that your understanding generally?
In general, yes. The land office is looking at a new bonding rule that will cover leases that lessees have with the land office.
Okay.
Oil and gas leases.
And I understand that, all of this stuff is, subject to change, but I did just want to, I guess, ask you whether that could result in double bonding if SLO and the commission don't kind of assess the impact of these bonding proposals. Is that fair?
I would say that again, I have to reread the SLO proposal again, but I know that part of it has to do with the number of wells on a lease. And so again, I'd have to dig deep and reread the land office proposal on bonding. Again, it's not something that I have spent an enormous amount of time looking
Understood.
at.
Understood. I think that's understandable given that they're fairly new proposals. I think to cover what our initial concerns are between the two, from slow and based on what's in front of the commission. So, Ms. Marks, is always a pleasure to listen to you testify, and really appreciate your time.
Thank you, Mr.
Thank you, Mr.
Swanzo.
Swanzo. Mr. Sayer, do you have questions of Ms. Marks? No? All right. Mr. Rankin, do you have questions of Ms. Marks?
I do not have questions of Ms. Marks. Thank you for your time, Ms. Marks. No questions on behalf of OCC.
Thank you. Mr. Maxwell, do you have questions of Ms. Marks?
No questions, Your Honor. Thank you.
Thank you. Ms. Nanausi, I'm not sure if you're with us on the platform. No. Mr. Tremaine, do you have questions of Ms. Marks?
I have two, I believe. Good afternoon, Ms. Marks. I'm Jesse Tremaine, representing the Oil Conservation Division. Ms. Marks, are you aware of circumstances where operators of wells on state leases report extremely low volumes of production, having the effect of those wells not triggering inactive well plugging under OCD's current rules?
I'm sorry, but can you break that up into?
Are you aware of circumstances where operators operating on state leases report very low volumes of production on their wells? Okay.
Yes.
And do you agree that such low reported production prevents those wells from falling into inactive status under OCD's current rules?
Well, I don't believe there's an inactive. Well, are you saying under 5.9?
Yes, 25.8 and 5.9. I understand that the actual well status and OCD permitting will remain active, but let me rephrase. So if an operator reports 1 MCF of gas in the previous 12 months, do you agree that that well will not fall onto the quote unquote inactive well list?
Under 5.9, yes, that's correct.
And in that case, do you agree that that well would not have to be plugged under 19.15.25.8?
That is correct under 25.8. Now, the land office itself may take different measures because there's a paying quantities determination that the land office may assess under the lease. We've, under our accountability and enforcement program, we've been taking other means to ask operators to plug wells. But yes, under 25.8 and 5.9, that is correct.
Okay.
Under OCD's rules.
Existing rules, right? Thank you. So my question to you is that in that circumstance where an operator is reporting an extremely low amount of production, and it's on a state lease, but yet that operator remains quote unquote in compliance with OCD, does that fact pattern have a potential impact on SLO's interest in the beneficial use of state minerals?
Well, as I noted, we have our leases say that a lease has to be in paying quantities. So we do a paying quantities determination, and we will send out paying quantities letters to operators at times. It's more difficult, I would argue, that operators sometimes sometimes we will see operators backdate production after we send out a no production letter, and then they backdate production to falsely report production, which is an issue. We then don't accept that production from the land office side. which is a whole nother set of issues. But if they're just reporting one MCF, or like one MCF, if it's in a comm well, for example, that won't hold a comm, because if there's a more than 60-day break in production on a comm well, that will the comm will terminate on its own. There's a whole set of factors related to the land office side, or like one barrel after if there's 60 days and there's a break in production after 60 days, that comm would terminate, and then the underlying lease would terminate. So there's a lot of factors. If it's just if there's one vertical well holding a lease that has one barrel, that would again, that you have to look at the lease terms, but that would not hold a lease for a year either. Because the lease would have had a break in, or you have to have a certain amount of production to hold the underlying lease.
Okay. Thank you, Ms. Marks. No further questions.
Great, thank you. Ms. Fox, do you have questions?
Thank you, Madam Hearing Officer. Just a few questions. Good afternoon to Ms. Marks. My name is Kyle Tizzle. I'm an attorney with the Western Environmental Law Center and represent the applicants in this matter. Thank you for your testimony today. In your direct testimony, you state that the commissioner strongly supports the proposed rule amendments. Is that correct?
That's correct.
And that's upon a full review of the rule that has been proposed and that is the subject of this rulemaking?
I did not review the entire rule. I only reviewed the portions related to well transfers.
Okay. But the commissioner strongly supports the entirety of the proposed rule, or just
I believe that's correct.
Okay, wonderful. Thank you. The State Land Office has had tremendous success in its accountability and enforcement program for plugging wells. Is that true?
That's correct.
Would you, please, yeah, just describe that program a little bit for us.
Sure. So under the accountability and enforcement program, the Land Office has, I believe to date, we've had 746 wells plugged and abandoned. And that is by asking the lessees of operators to make sure on the leases that we have issued, to make sure those operators have make sure the operators on those leases sorry, I apologize. For example, if we issue a lease to somebody, we will make sure that the lessee of record goes after whomever they have parsed out certain debt severances to, or someone they have maybe an override, but they have allowed another person to be an operator of record on that lease. Then we will pursue that lessee of record to P&A that well, but that is no longer active and producing. Say an operator has left the state, has become insolvent, filed for bankruptcy. It's just, or in another case, for example, they've created a huge environmental mess. We will pursue the lessee of record to clean up those messes. We've filed, I believe, 38 cases have been filed. We've resolved 18 of those. A lot of these can be resolved without filing a lawsuit. There's a lot of good operators that we work with, but a lot of the good operators we work with, they're operators, but they're also lessees. A lot of those lessees have stepped up and actually plugged and abandoned the not so great operators' wells on those leases.
Thank you. That's 746 wells is a lot. How many?
in addition to those, I'm sorry, we also do lease assignment reviews within my division. So in addition to those 746 under the accountability and enforcement program, we also get a number of kind of more very poor performing wells. We get those plugged separate from the accountability and enforcement program. So we'll get spills cleaned up and wells plugged under the unit review process or just the lease assignment review process. So that's in addition to wells that have been plugged or sites cleaned up vis-a-vis the accountability and enforcement program.
Over how many years would you say that the 746 wells that have been plugged, over how many years has that program been in operation to get those wells plugged?
Either 4 or 5 years.
Okay, well. And the relationship between the state land office, I think you spoke to this earlier, the relationship is somewhat unique in that those enforcement matters are going to the lessee rather than just the operator. Is that correct?
Yes, often we'll reach out to the lessee of record, and sometimes we reach out to the operator as well. But yes, we reach out to the lessee of record because obviously we have a contract, lease is a contract. So we will reach out to the lessee of record and say, here's an outstanding liability on your lease.
And so those 746 wells, are those all wells that were not producing for some period of time before the enforcement action was taken?
So I don't want to say a definitive yes, that they were not all not producing, but more than likely the answer is yes. But a lot of them could have been very poor stripper wells, or they could have had, as Mr. Tremaine said, they could have had, you know, one barrel of oil, and then they could have had, you know, a break of 5 months and then another barrel of oil. And then they were plugged then. I do know we had one company who was the lessee of record, and then another operator had, you know, there was a farm out agreement where this operator was producing, had a well on that lease, and then the operator was falsifying production records, submitting them with OCD, and then that led to this like 1 barrel and then a break in 6 months and then another barrel. Meanwhile, the lessee of record had very prolific wells on that lease, and so that lease was otherwise being held by great production in lower formations, but the shallow formation had at least one terrible well on it that needed to be plugged.
And then I believe your testimony was, in addition to the accountability and enforcement program, you also run a lease assignment review program that also catches wells that are underperforming.
Correct. Yeah. So before a lease can be assigned to a new lessee, we make sure that the lease is in good standing. So that includes doing an environmental review and also looking holistically at the wells on the lease. We have to make sure that that they're not inactive wells, that they're in compliance with OCD rules. And then there are other factors as well to make sure that the lease is, quote, in good standing. Yeah, it's under 19.2.100.41, I believe, of the New Mexico Administrative Code.
I don't want to, I don't want to belabor the point, but on a lease assignment review, that is a process by which a lease could be basically reassigned from one lessee to another lessee. Is that what I'm hearing from your testimony?
That's correct. And we also do it for units as well. So one unit going from one unit operator to another unit operator.
And the intention of that is to basically have that lease or unit put into more productive use than the prior lessee. Is that correct?
I wouldn't necessarily characterize it that way. So a lease could go from, say, Chevron to Conoco, and certain times companies do trades with one another, and so there's various reasons that leases change hands.
Okay. And I imagine you haven't been sitting through the entirety of testimony that we've been going through up to this point.
Not at all.
No, okay. There was some testimony that we heard earlier about just well plugging that has taken place over 2024. And there was roughly 3 categories of wells that were plugged in 2024 in that testimony. One category was OCD plugging, the wells that OCD itself is plugging. Another category of wells were the wells that operators are plugging themselves. And then there was a third category that people were having a hard time pinning down, but that was called forced plugging. Are you aware, generally speaking, of those 3 categories of wells?
I'm not sure. I mean, I can speculate what the term forced plugging means. I'm guessing that's when the land office is asking somebody to plug a well. Is that, I don't know if someone wants to correct me, but I'm guessing.
I believe that is correct. I was just wondering if, but I'm not testifying obviously in this case. So I was just wondering whether you had any information that you could help shed light on that category. But thank you so much. Yeah.
Yeah. No, I do know we asked people to plug wells. So if that is what that is referring to, yes, we do. We do force companies, like I mentioned earlier. We have sent out numerous demand letters, and before we will approve an assignment or certain change of unit operators, or these certain suits that have been filed or certain settlements, we do require certain lessees of record to make sure certain wells are plugged, and a lot of companies have been great to work with and have plugged those wells.
Great. Thank you so much, Ms. Marks. Those are all the questions that I have. Thank you.
Thank you, Mr. Tisdale. Commissioner Mpoma, sorry, I forgot to ask. Mr. Moore, do you have any redirect?
Just a very limited, Madam Hearing Examiner. Thank you. Ms. Marks, your direct testimony in this case concerns the rules, the rule amendments at issue in the application, and not any potential upcoming changes to state land office regulations. Is that correct?
That's correct.
All right. I think that is it for redirect. Thank you, Madam Hearing Examiner.
Thank you, Mr. Moore. Commissioner Mpoma, do you have questions of Ms. Marks?
No, I do not. Thank you.
Commissioner Bloom?
Yes, thank you. Thank you, Ms. Marks. Just a couple questions. And thank you for being here. We put up a firewall at the land office. So as I started preparing for this hearing, that was the first time I saw that the land office was going to be here as a participant. So thank you. Ms. Marks, just wanted to clear up some things. I think we got off on a little bit of a tangent about the land office's bonding efforts, but you mentioned that the land office bonding effort is focused on bonding the lease, correct?
I believe it is, yes.
Yeah. And then I think you said maybe it depends on the number of wells on the lease. Are you sure about that? It was not my recollection, and I don't believe it to be the case. So I wanted to let you reconsider that answer.
I am not sure about that. And so I have not, I read that quite some time ago, and I have not read it again. So yes, that's why I was stumbling quite a bit through that. So I will move to strike my own answer there because I do not, that is a quite a beast of a rule that I have yet to read again. So
Thank you. Yes, I
if the
believe
court
this is more of
reporter
an,
could strike my answer, that would be great.
okay, I believe this is more of an effort coming out of the Office of General Counsel than it is your division, correct?
That is very correct. Thank
Okay.
you.
And then Ms. Marks, you received some questions regarding double bonding, and I don't know if you heard testimony today, but I believe Mr. Powell answered on cross-examination that the land office cannot call or take OCD bonds. Is that your understanding?
Yes, the land office cannot, to the best of my knowledge, demand that OCD pull a bond.
Yeah. And then just to make sure we don't have any misunderstandings coming out of this hearing, under the land office's proposal under section E called periodic adjustment and review of bonding levels, point number 3 says, in the event that a well bond or other financial assistance on file with the New Mexico Oil Conservation Division would cover operations on a particular lease, and the Oil and Gas Act and New Mexico Oil Conservation Commission rules are changed to allow the commissioner to access such bond or other financial assurance, the commissioner may adjust downward the monetary value of the bond required under this rule by the amount of the bond or other financial assurance on file with the New Mexico Oil Conservation Division that is applicable to wells on state trust land. So as I read that, it says that currently the land office does not believe it can access OCD bonds, and therefore we're not seeing overlapping bonding at this point because the land office can't take those bonds. Does that make sense to you?
I'm sorry, were you reading from this current rule before the commission?
No, that was the land office draft rule for its own bonding effort. So
okay. Sorry, do you want to reread that and then I can answer?
I'll drop the question. I don't think it's particularly germane. Well, no, I'm sorry. I will read parts of that again for you. This is E3, and it says that in the event that a well bond or other financial assurance on file with the New Mexico OCD would cover operations on a particular lease, and the Oil and Gas Act and New Mexico Oil Conservation Commission rules are changed to allow the commissioner to access such bond or other financial assurance, the commissioner may adjust downward the monetary value of the bond required under this rule. So I'm hoping that again underscores that the land office cannot call or take OCD bonds. Again, would that be your position?
I agree. If the with the way any rule and statute reads right now, I do not believe the land office can currently call any OCD bond.
Okay, thank you. And Madam Hearing Officer, I don't know if it would be appropriate, but just for ease of document management, would the land office be able to submit their proposed changes as a red line?
Typically at the end of a rulemaking, I invite all parties who would like to submit kind of a final proposed red line or any written closing arguments to do that. Is there any reason that wouldn't be appropriate in this case? I'll pause to hear from the petitioners or anyone else. No? All right. Commissioner Bloom, I am not hearing any objections to that plan, which again is our usual practice in a complex rulemaking.
Thank you very much, Madam Hearing Officer. I think that'd be helpful. We're managing, I think, a few different versions of the rule currently, or we've seen a few different ones come around. And so having that final submission from parties that would wish to submit them, I believe would be helpful. Ms. Marks, thank you. I don't have any further questions from you or the land office. Thanks for your time.
Thank you.
Thank you, Commissioner Bloom. Chair Chang, do you have questions of Ms. Marks?
I do not. Thank you.
All right, thank you very much, Ms. Marks.
Thank you.
We'll excuse you. I think, do we have time here for Oxy's opening statement?
Madam Hearing Officer, thank you. I actually haven't timed myself on this, but do you want, if the commission wants to take a break before public comment, I would say no. But if we want to go straight up to public comment, I may be able to squeeze it in. But
Yeah, we've only been going 40 minutes.
Yeah.
So let's squeeze it in. And if you go a few minutes after 4, that's fine. I only have 4 folks who asked to offer comment at 4 p.m. So I think we'll be fine.
Thank you, Madam Hearing Officer. Madam Hearing Officer, Commissioner Chang, Commissioners Zampoma and Bloom, thank you very much for consideration of Oxy's presentation of its case and consideration of its proposed modifications to the rule submitted by applicants. Oxy supports reasonable, targeted, and administratively efficient and effective regulations governing financial assurance requirements for operators of oil and gas wells in the state that make sufficient funds available to the division to cover the plugging of wells on state or fee lands in the event an operator becomes insolvent. But the regulations should narrowly focus on the operators and operations most at risk of orphaning wells and stay within the legislative grant of authority. Section 70-2-14 of the Oil and Gas Act authorizes the Oil Conservation Division and Commission to acquire operators in New Mexico to provide financial assurance for plugging wells on state and fee lands. Subsection A of that statute sets out the reach and limits of the authority. But rather than stay within the scope of the framework, the proposed rule, while well-intended, strains the language of the statute beyond breaking and beyond what the legislature intended or authorized. That puts the rule as proposed at risk of being challenged and overturned, and because the proposed rule steps outside the confines of the statutory framework, increases the chances of unintended adverse consequences proliferating if it is adopted without modification. The statute sets out 2 mandates that are ignored and violated in our view of the proposed rule. First, the statute requires and provides for operators to have the option for one well financial assurance or to elect blanket financial assurance capped at $250,000. Second, it authorizes increased financial assurance through one well bonds only after a well has been held in temporarily abandoned status for more than 2 years. Oxy does not object to applicants' proposed increase of the financial assurance required for active or inactive wells. However, applicants' proposal to create a new category of financial assurance for what it deems as marginal wells and marginal operators exceeds the statutory restrictions under the statute. Applicants' further efforts to remove the 2-year period provided for under the statute for wells in temporarily abandoned status, allowing them to remain under an operator's active blanket financial assurance, is also improper. Applicants seek to create a new financial assurance category for what it defines as marginal wells by imposing a new category or new requirement for these active producing wells that removes them from the $250,000 blanket financial assurance option provided under the statute and requires instead a one well financial assurance of $150,000 for each well. Applicants also seek to create a new category for marginal well operators that would require operators with more than 15% of their marginal or inactive wells in their portfolio to pay a one well financial assurance of $150,000, not just for each marginal well, but for each of its other active producing wells, even though those active and producing wells do not meet the rule's definition for a marginal well. That, in our view, is regulatory overreach and not targeted towards the wells and operators that the division says are the problem. It's also contrary to the plain language of the statute and the legislature's intent, and we know this by reviewing the statute's history. Section 70-2-14A has been periodically modified by the legislature, with the most recent amendments in 2015 and 2018. The 2015 amendment created a category of financial assurance for temporarily abandonment status wells and authorized this new category of financial assurance to exceed $50,000. At the time of the 2015 amendment, before the $250,000 cap was set, the statute did not allow financial assurance to exceed $50,000. That was the limit. But this 2015 amendment therefore specifically authorized financial assurance for temporarily abandonment status wells to exceed the general statutory cap of $50,000. Then in 2018, the legislature increased the general statutory restriction on financial assurance by a factor of 5 from 50,000 to 250,000. Accordingly, the statute today instructs that an operator is authorized to elect a blanket plugging financial assurance that cannot exceed $250,000. The blanket plugging financial assurance for temporarily abandonment status wells must exceed $50,000. And one well plugging financial assurance is authorized for a well that has been held in temporarily abandonment status for more than 2 years, but an operator has the option to place these wells under blanket financial assurance. Applicants' proposed financial assurance for active wells recognizes and remains within the $250,000 statutory cap that the legislature established back in 2018. However, in an effort to work around that statutory restriction for its proposed new category of financial assurance addressing active marginal wells, the applicants asked the commission to define a marginal well, remove the active wells from the $250,000 financial cap, require a one well plugging financial assurance in the amount of $150,000 for each of these active marginal wells. And if over 50% of an operator's portfolio are considered to be marginal or inactive or a combination, then the operator is being required to provide financial assurance of $150,000, not just for each marginal well, but for each of its wells overall, including wells that are not defined as marginal. Unlike in 2015, when the legislature created the financial blanket bond for temporarily abandonment status wells that expressly authorized the category of financial assurance to exceed the statutory cap, the legislature has not taken any steps to authorize the commission to exceed the cap for active marginal wells or any other category of financial assurance. The legislature also has not authorized the commission to remove active producing wells from the $250,000 cap that's in place, nor they authorize them to require the commission to require one well financial assurance for each of these active producing wells. Instead, the legislature has limited the one well financial assurance authority to a well that has been held in a temporarily abandonment status for more than 2 years. If, as applicants suggest, the commission can always require one well financial assurance for any category of well, then the $250,000 financial assurance restriction that's been in place and the specific one well financial assurance authorized set forth under the statute have no meaning and are rendered superfluous. And as noted in the statement filed by OCC witness Tiffany Wallace, any concerns with marginal wells can be addressed by the presumption of no beneficial use provision that's proposed by applicants. As proposed, a notice of no beneficial use is triggered if in a consecutive 12-month period, the well has not produced at least 90 days and has not produced 90 barrels of oil equivalent. That provision is narrow and targeted and allows the division to take action against specific operators for specific wells that are at risk of truly being orphaned, and to do so early in the process of abandonment, just as the division says it needs to be able to do. Now, this presumption and the subsequent notice required and response required by the provision addresses any concerns with marginal wells without running afoul of the statutory limits. We'll talk about inactive wells real quick. OCC does not object to applicants' proposal to increase the financial assurance for inactive wells. However, the proposed change to inactive well financial assurance do not comply with the financial assurance statute. The current financial assurance rule complies with the statute and recognizes that increased financial assurance applies only to any well that has been held in temporarily abandoned status for more than 2 years. In adopting this rule back in 2005, the Commission recognized that this statutory restriction is in place, which rests on the fact that a well in approved TA status has been vetted by the division, including a review of the condition of its casing and cement, and can therefore remain covered under the statutory blanket bond of $250,000, at least for the first 2 years. Applicants' proposed changes instead requires increased financial assurance for wells in approved temporary abandoned status immediately, as soon as they're put into that status. Now, this contradicts, in our view, the legislative directive allowing wells in approved TA status to remain under the $250,000 cap for at least the first 2 years, forgive me. On to operator certification and registration. OCC supports the rule revisions that are designed, in our view, to determine whether new operators seeking authority to operate in the state and existing operators looking to acquire new assets in New Mexico do not have a history of financial assurance forfeitures in other states. As noted in the statement of Oxy's witness, Tiffany Wallace, Oxy has proposed modifications to the operator registration and change of operator provisions that are designed to provide a certification that can be met by large operators with diverse portfolios in multiple states. This proposal modifications are efficient, administratively efficient, and they provide the division with information to gauge whether an operator has had difficulty meeting financial obligations in other states. And we understand the applicants in the division have accepted Oxy's considerations and proposal, and we're grateful for that consideration. On the presumption of no beneficial use, Oxy supports the proposal as presented, and as explained by Oxy's witness, Tiffany Wallace. Oxy has proposed only a few modifications designed, in our view, to avoid unnecessary mandatory submissions of categories of information that are repetitive or may not fit a particular circumstance, giving OCD discretion to request submission of relevant documents only. On the amendments to the TA status wells, Oxy supports reasonable and administratively efficient regulations governing the placement of wells in TA status, but strongly urges the Commission to ensure that the division retains discretion to approve TA status for additional discrete periods, such as 5-year increments, based on reasonable and relevant information to support the request. Oxy proposes to retain much of applicants' proposals for what is required for the initial TA approval, but proposes modifications to allow the division approvals for additional TA periods, as we've discussed. As to the adjudicatory requirements for TAs going beyond the initial extension period, requiring those to go to hearing, Oxy proposes that all TA extension requests go to the division. Applicants propose that all the TA extension requests beyond the first one go to the division hearing, and that any interested party be allowed to intervene to participate. As noted by Oxy's witness, Tiffany Wallace, in her testimony, the division's current dockets for adjudicatory hearings are at capacity. There's no administrative reason to further burden the docket with requests for extensions of an approved temporary abandonment status. Similarly, the request to eliminate the requirement of that an interested party demonstrates standing first to intervene in an adjudicatory hearing is unnecessary, inappropriate, and our view will further burden the division's crowded hearing docket. So with that, let me just give you a quick overview of our witnesses. Oxy has 2 witnesses who have presented both direct and rebuttal testimony. First is Tiffany Wallace. Ms. Wallace has previously testified before the Commission on rulemaking issues in her capacity as the Deputy Director of the Commission division previously. She currently manages policy and external affairs for Oxy in the lower 48 states, including New Mexico, and has had several engineering and leadership positions in the oil and gas industry for 20 years before she joined the division in 2020. Prior to joining the division, she was the development director for Marathon, overseeing oil and gas assets in the Delaware Basin in New Mexico. And her responsibilities included overseeing more than 100 employees on subsurface geoscience, reservoir engineering, and planning type support groups, including production, engineering, and operations and regulatory. And her direct testimony provides an overview of Oxy's recommended modifications and provides reasons for the requested changes. Her rebuttal testimony responds to specific assertions that marginal wells hold little value other than to hold a lease by providing case studies of specific wells that would qualify as marginal under the definition of the proposed rule that Oxy was able to return to improve production, demonstrating their value. She will have a short rebuttal as well. Second witness is Ms. Kelly Montgomery. She has a Bachelor of Science in Mechanical Engineering and is a registered professional engineer in Texas. She serves as Oxy's regulatory manager for the Permian Basin for more than 10 years and has testified before the Commission on new and expanded enhanced oil recovery projects and is familiar with the division's regulatory process. She's currently Oxy's Vice President for Air Programs and has a BS as well in Mechanical Engineering, and is a registered professional engineer in Texas. I think I said that already. Her direct rebuttal testimony are focused on the narrow issue of the rules changes to the TA status of approvals and extensions and the impacts potentially on Oxy's enhanced oil recovery program, which covers more than 15,000 acres and involve more than 500 wells that have been or will be converted over time to injection producing wells or monitoring wells. She explains that EOR projects are sensitive to economics and benefit from a large inventory of wells for use as injectors, producers, or monitoring wells in the future. This testimony in combination highlights the risks that this proposed rule poses for causing waste and impairing corella rights, and we appreciate your attention to OCCC's testimony today. Thank you.
Thank you, Mr. Rankin. Sheila, do we have our interpreter on the platform?
I'm not seeing her on here yet, and I have the company contacting her to see if maybe she signed in under a different name or something, but I haven't heard from her.
All right, let me just ask if you are our interpreter for public comment today and you're on the platform, please raise your virtual hand. No. Okay. Let's see here. I think first I'll invite, while we wait for the interpreter to arrive, I'll invite those who are not requesting interpretation between Spanish and English or English and Spanish. I have 4 names on the sheet. Just a few things about public comment. I will ask you to spell your first and last name for the transcript. I will ask you, pursuant to commission rules, to swear or affirm that you will tell the truth. And I will ask you to keep your comments verbally to 3 minutes. If you have more to say than can fit in that time, please submit your comments in writing to Sheila Apodaca, the commission clerk. So I see a